And finally, we have a member from Japan of the World Jurist Association, Kaori Matsumoto. Kaori, do you want to mention the brief overview of the guidelines and tests applicable for determination of legitimacy of the restrictions of the freedom of speech, please? Could you come up? Oh, you here? Sure.
Yes, thank you so much. So it's a great honor. Can you hear me? It's a great honor and privilege to meet with all distinguished panelists and the guests. And thank you so much for inviting me here. Before I was working in the United Nations Office on Drugs and Crime as a crime prevention and criminal justice officer. And there I was in charge of establishment of the Judicial Cooperation Network for Southeast Asia region. And it was established in 1 year and expanded beyond the 12 Southeast Asian countries. And now the member includes from the US and also European countries, Pacific, and other Asian countries too. So from this point of view, I really see a lot of value that the distinguished jurists come here and talk about those important topics related to rule of law. So thank you so much. And after hearing all those, there is a saying in Japan, like teaching Buddhism to Buddha. That is exactly my situation now. But okay, but please allow me to highlight some key legal instruments and helpful tools related to the freedom of speech and expression. So since it was abuse of the rule of law, and it's reinforced in limit on the freedom of expression, and this was mentioned by President Ricardo, yes. And also the connection of freedom of speech and freedom of thoughts. It was also mentioned by President Ricardo, President Gressa as well, and also Professor Leiner too. I believe at this timing it would be helpful to clarify the fundamental rules regarding the limitations and restrictions on freedom of expression and speech. So there are some key cases regarding that, and also the threshold tests often used based on the case law, as well as the guideline made by the OHCHR. So please allow me to mention those briefly. First of all, freedom of expression is enshrined in Article 19 of the Universal Declaration of Human Rights. It is also influenced in a number of international, regional, and national legal instruments, declarations, as well as observations by various treaty bodies, and in UN reports and resolutions. Those include Article 19, Paragraph 2, of the ICCPR and the Article 10, Paragraph 1 of the European Convention of Human Rights. So according to Article 19 of the ICCPR and the UN Human Rights Committee's General Comment number 34, the freedom of expression includes the media freedom and other rights of journalists, cultural and artistic expression, teaching, and religious discourse too. Also, the right covers communications that are both oral and written, and all modes of communication, including audiovisual, digital, and internet-based communications. And on the other hand, the freedom of expression is a non-absolute right, which means it can be legitimately restricted in certain circumstances. The limitation on the freedom of expression is, for example, stipulated in Article 19, Paragraph 3 of the ICCPR and Article 10, Paragraph 2 of the European Convention on Human Rights. Also, Article 20, Paragraph 2 of the ICCPR requires states to prohibit certain severe forms of hate speech. That was also mentioned by Professor Reiner. It is of great importance to have certain standards and guidance to correctly interpret those restrictions to the freedom of expression. In this regard, I wish to highlight some key tests and case laws, as well as guidelines for such interpretation of restrictions to the freedom of expression. Those include tests used under Article 19, Paragraph 3 of the ICCPR, tests used under Article 10, Paragraph 2 of the European Court of Human Rights, and its cornerstone case law, Handyside versus UK case, which is one of the first and most important case laws in relation to the freedom of speech, as well as the sixth threshold test of the Rabat Action Plan for examining if the speech will amount to the hate speech stipulated under Article 20, Paragraph 2 of the ICCPR. So first, under Article 19, Paragraph 3 of ICCPR, a four-part test is used to assess whether such a restriction is justified. First, the restriction must be provided by law. Second, it must pursue a legitimate aim. And third, it must be necessary to protect a legitimate aim. And then fourth, the extent of the limitation must be proportionate in pursuit of the identified legitimate aim. Then, what can be the legitimate aims? The ICCPR provides an exhaustive list of legitimate aims. First, the rights or reputations of others. Protection of the rights or reputations of others. Or second, the protection of national security. Third, the maintenance of public order. Fourth, public health or morals. We also have to ask, does the restriction respect the principle of equality? Is it non-discriminatory? Members that limit freedom of expression in discriminatory manner, or measures that limit freedom of expression in a discriminatory way will fail the test of proportionality. So whether the restriction is made in a discriminatory manner or not is considered as one aspect of one criteria for the necessity and proportionality test. Only all of these criteria are met, restriction on the freedom of expression is permissible. A similar test applies to the right to freedom of expression under other legal instruments. As you know, the European Court of Human Rights has a cornerstone case on the freedom of expression in 1976, Handyside versus UK case. Although the court found that the case itself did not violate the right to freedom of expression, the judgment read as a whole sets a strong general standard for the protection of the right to freedom of expression. In particular, the paragraph 49 has become a cornerstone of freedom of expression jurisprudence. Let me read the paragraph 49 as it includes so many important dictums. Citation, freedom of expression constitutes one of the essential foundations of such a society, one of the basic conditions for the progress and for the development of every man. The freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population, such as the demands of the pluralism, totally different meaning, pluralism, tolerance, and broad-mindedness, without which there is no democratic society. This means, amongst other things, that every formality, condition, restriction, or penalty imposed in the sphere must be proportionate to the legitimate aim pursued. So proportionality principle appears here. The Handyside case has been cited by a number of courts around the world as one of the most important judgments in freedom of expression cases, and it is applied up until today. Taking the Handyside judgment into consideration, restriction test on the protection afforded by Article 10, freedom of expression of the European Convention on Human Rights are: first, threshold, if an interference is a freedom of expression exists. Second, if the interference is prescribed by law. And third, pursues one or more legitimate aims. And finally, fourth, if it is necessary in a democratic society to achieve these aims, which is very similar to the test under ICCPR. As set forth in Article 10 of European Court of Human Rights, freedom of expression is subject to exceptions, which must, however, be construed strictly, and the need for any restrictions must be established convincingly. This was made further clearer in Stoll versus Switzerland case, and also in Maurice versus France case. In relation to the hate speech, so I wish to mention the hate speech as well. The freedom of expression also has limitations stipulated in Article 20, paragraph 2 of the ICCPR. In order to interpret such restriction in light of its object and purpose and protect the freedom of speech, it is very important to have certain standard in distinguishing between permissible speech and speech that may amount to the hate speech. So what would be the hate speech? In this regard, as a useful international guideline, I wish to mention the Rabat Plan of Action, which is developed by the UN Office of High Commissioner on Human Rights, OHCHR, through its expert workshops. It suggests a high standard for defining restrictions on freedom of expression, incitement to hatred, and serves as practical legal and policy guidance to states on interpretation and implementation of Article 20, paragraph 2 of the ICCPR. The Rabat Action Plan makes several recommendations to states, civil societies, media, companies on how to best deal with any tensions that may arise between freedom of expression and the prohibition of incitement to violence. It has the 6 threshold test to understand whether a certain statement meets the threshold of incitement to hatred or not. First, the social and political context. Second, status of speaker. Third, intent to incite the audience against the target group. Fourth, content and the form of the speech. Fifth, extent of its dissemination. And sixth, likelihood of harm, including imminence. So it is a helpful guideline and summarized in one paper. I understand that the Rabat Plan of Actions threshold test is translated into 32 languages by OHCHR in cooperation with Facebook. So I have it here if you want, maybe with the help. Yes. And one of the good practices of utilizing the Rabat Plan of Action threshold test is in 2021, Facebook's oversight board referred in several decisions to the Rabat Plan of Action, using its 6 threshold to assess the capacity of speech to create a serious risk of inciting discrimination, violence, or other lawless action. So as conclusion, what kind of latitude human rights bodies would give on restrictions on freedom of speech is restrictive. This point has been repeated in so many cases since a democratic society is built on the ability of people to express their views, and there is an important demand of pluralism. Thank you so much.